Assalamualaikum warahmatullahi wabarakatuh and good evening to everyone that is watching my video. Hi, my name is Saisha Bisam Mustafa, and today, by the title, today we are looking on construction laws, delays, liquidated, and ascertained damage, extension of time. So, without further ado, let's begin. In Malaysia, construction contract is a time is a critical element when a contractor fails to complete the works by stipulated the completion date. The employer suffers a massive loss. And the three main standard form that we'll be looking through is the PW 203A, PAM 2018, and CIDB 2000. By looking at this, they will provide mechanism to manage the delay throughout the extension of time (EOT) and the compensate the employer throughout the liquidated and asserted damage, also known as LED. An extension of time is a contractual mechanism that relieves the contractor from liability for damages for a specific period by existing the original completion date. It is an act as a shield for contractor against the LED claims. The purpose of the EOT clauses, the primary purpose of an EOT clause is to preserve the employer right to claim LED for delays that are contractor fault. Without such a clause, if it's a delay, even one clause by the employer, the original completion date become legally and unconfessable, also known as time at large, and the employer may lose the right of conducted LED. So, to justify my statement just now, we are going to see the examples of the law, which is a real life law case between these objectives that I just talked about, where the case of the law related to the delays, liquidated, and certain damages, LED and EOT, extension of time. Without further ado, let's begin. The first one is Tunisia as the Berhad against Anor. In this case involves the PW 203A, the form the contractor was granted the extension of time and completion and they objectively complete the work. However, they submitted their claim for a loss and expense 19 days after the certificate of practical completion CPC without having a given the mandatory 30-day written notice of the intention claim at the delay occurred. With that being said, the High Court initially disallowed the claim while the Court of Appeal later allowed it regarding the interpretations of loss and expenses. The case remains critical situation between this that can be fatal to claim even if the delay was not being in construction fault. And the second case that we can talk is the Daya CMD Sdn Bhd and Abogasi Yongtong Construction Sdn Bhd. The contractor tried to argue the prevention principle that the employer actions prevent the completion, thus voiding the completion date, without having applied for the EOTs at the relevant time. The Court of Appeal held that while the pretending officer could verify an EOT in obvious cases is not a duty. The obligation remains that the contractor to apply for EOT by giving timers written notice. Fail to do so, the boss contractor from later asserting the prevent principle. Was that being said that the concurrent delay occurs when two more delay events happen at the same time or overlapping, where in one relevant event entitling the contractor to AOT and the other contractor cause delay. Because the general rules is that if there is an employee delay or no contract delay, which equals to EOT plus a loss expression cost. But if there's an employee delay, which is the contract delay, will automatically an extension of time, but without the cost. So that means the contractor gets time relief to avoid LED but does not get paid for the period of overlap because they were also contributing to the delay, and the contractor cannot profit from their own delay. In conclusion, in Malaysia, the management of delay under PWD 203A, PAM 218 and CIDB 2000 is governed by strict rules, which is notice is everything. Cases like Sunisa and Daya CFT that confirm that Malaysian courts strict threat notice requirement as condition presenters failure to receive written notice within stipulated time for 1 month, 30 days of 4P WD or 28 days of PM can invalidate the claim of extension of time or loss expansion. That's all for me. I hope you guys enjoyed this video. Bye and Assalamualaikum.